All right, buckle up because this courtroom hearing is not just serious. It's career-ending serious. This is People versus Sean L. Jordan, and we're stepping into a case that has every single red flag you see in high-stakes domestic violence prosecutions. A reluctant witness, major felony charges, and the kind of courtroom tension that makes you feel like the walls are closing in. Here's what you need to understand going in. This is a preliminary examination, not a trial. Nobody is getting guilty or not guilty today. What the judge is deciding is whether there's enough evidence, probable cause, to send this case up to a higher court. And when we say the stakes are high, we mean mandatory minimum high. One of these charges is filed in a way that could force 25 years minimum if there's a conviction. No good behavior, no judge goes easy, 25 years. And right away, we see something that screams drama. The judge knows the defendant personally. I've known you since you were in high school. That's not favoritism, but it does add weight. Because when someone you watched grow up ends up in front of you charged with alleged strangulation.
All right, we're back on the record. This is file number 231670. People versus Sean L. Jordan. That's you, sir?
Yes, sir.
And I've known you since you were in high school, but I'm identifying you for the record. You're charged with some very serious offenses. It's alleged that on or about August 27th, you did knowingly restrain Jesse Pike to facilitate the commission of assault with strangulation or suffocation, a felony. That unlawful imprisonment charge is punishable by up to 15 years in prison and a fine of up to $20,000. Count 2 is assault with intent to do great bodily harm less than murder by strangulation. You did make an assault upon Jesse Pike by strangulation or suffocation, contrary to the statute. That is a felony punishable by up to 10 years imprisonment and a fine of up to $5,000. Count 3 is aggravated domestic violence that you did inflict upon Jesse Pike, who you had a dating relationship with, a serious or aggravated injury.
Excuse me, I believe there's an amended complaint.
Is there? I just printed this yesterday. We got another one.
The amended complaint was filed a couple of weeks ago.
Well, once again, I didn't scroll down far enough. The same thing happened yesterday, so it's on me. Unlawful imprisonment, assault, great bodily harm. Count 2. Count 3, assault, great bodily harm. Same suffocation. And count 4 is aggravated domestic assault. That's a misdemeanor charged as a fourth habitual offender, making this a mandatory minimum 25-year sentence.
Okay, pause right there, because this is one of the most important legal bombs in the entire video. A misdemeanor becomes a 25-year mandatory minimum because it's charged as a fourth habitual offender. That sounds insane to regular people, because it is insane in terms of consequences. But legally, habitual offender enhancements are designed to hammer repeat offenders. Think of it like the court saying, you've had chances, you kept reoffending, now the gloves come off. And notice how the judge frames it. Very significant charge. That's judicial code for, you are in deep trouble. 25 years mandatory minimum means if convicted, the judge can't just get emotional and go easy. This isn't one of those time-served anger management probation situations. This is prison, and not the short kind. And this isn't even trial yet. And this is prelim stage, but prosecutors are already stacking the case like a tower. Unlawful imprisonment, assault by strangulation, domestic violence. They're building a narrative that the victim wasn't just harmed, she was trapped, controlled, and physically overpowered. Audience question, if you're the defendant and you hear mandatory minimum 25 years, do you still gamble on trial or do you take a plea deal immediately? Because we're about to hear one.
So this is a very significant charge, Mr. Jordan. this is a preliminary examination where it must be established that it's probable cause to believe that a crime was committed and probable cause that you did it. You don't get found guilty or not guilty at this hearing. But if it goes to circuit court and you get convicted, you have to do 25 years in prison, the way this is charged. Mr. David Marvin, the county prosecuting attorney, is here. Mr. Marvin, is there a plea offer?
Give me 1 second. Your Honor, to answer your question, there was an offer. It was count 2 and count 4. Dismiss the remainder, and that does eliminate the mandatory 25-year sentence. That was restated, and now I defer to John Bush.
All right, count 2 is assault with intent to do great bodily harm. Count 4 is aggravated domestic assault. The lawful imprisonment, the other charge, and the supplemental would be dismissed. Mr. Bush, have you had a chance to discuss that with your client?
I had, that was the same offer that we've had before, Your Honor, and he said no then, and he's also telling me no when he wants a prelim today.
Very well. All right, Mr. Marvin, are you ready to proceed?
I am. I don't often ask for an opening statement, but would the court allow that?
Certainly.
All right. Your Honor, I think we'll do the best we can today. There are a number of ways of getting testimony in situations like this when you've got a victim who's very reluctant. And but I just wanted to let the court know that today I'll be asking questions about the Sean Jordan who acted on the day of this incident, and not the Sean Jordan that Jesse Pike.
That prosecutor line is actually brilliant and emotionally loaded. He's preparing the court for what's coming. The victim may try to protect the defendant. And in domestic violence cases, that's not rare. It's practically expected. Victims may minimize, deny, shut down, or rewrite the timeline because of fear, love, trauma bonding, financial dependency, family pressure, or all of the above. By saying not the Sean Jordan she really cares for, the prosecutor is doing two things. He's humanizing the victim so the judge doesn't just see her as uncooperative. He's telling the court, even if she softens now, don't be fooled. An incident still happened. And it matters because this hearing is about probable cause. Yeah, the prosecutor doesn't need a perfect witness today. He needs enough credible evidence to show a crime likely occurred. But here's the danger. If the witness won't speak clearly under oath, the prosecutor may be forced into Plan B, relying on police testimony, prior statements, and statutory exceptions. And judges, they get very cautious when the case starts leaning on hearsay. This is the moment where the tone of the entire prelim shifts. We're not just watching testimony. We're watching a prosecutor try to save a collapsing case in real time.
Really cares for. And I just wanted to let the court know and remind Jesse Pike of that.
All right. Mr. Bush, any opening from you?
No, no.
Ms. Pike, would you come up and take the witness stand? Why don't you bring that box of Kleenexes right up with you? Would you please face me and raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
All right, have a seat and state your name, please.
Jesse Anna Pike,
Could you spell your name for us?
Jessey, and then Dike.
ANNA.
Yeah.
All right, I ask you to keep your voice up. Mr. Marvin has some questions for you.
Good afternoon, Jesse.
Yes.
All right, and say it again, because you're gonna have to speak very clearly and loudly.
Good afternoon.
All right. Jesse, do you recall August 27th, 2023?
Yeah,
Do you know the day?
not exactly like the day of the week.
All right. On or about August 27th of 2023, did you contact law enforcement?
Yes.
What was that?
Yeah,
Okay. Where were you?
the bedroom,
But where were you? What address?
1135 Millard Court.
In Three Rivers?
Yes.
All right, that's in St. Joseph County.
Yes, I'm
Okay.
not from here, so yeah.
All right. So you contacted law enforcement. Would you tell the court, why did you contact law enforcement?
I was frightened and I just wanted,
Could you please?
I was frightened and wanted help, like to get separated.
Okay, so you're calling for help. And why were you calling for help? Just big terms. Why were you calling for help?
Argument.
And arguing with whom? Could you say who?
Sean Jordan,
All right, and do you see him today? And where is he?
sitting right there.
All right, Your Honor, she nodded, may the record reflect, she nodded towards defendant.
It may.
Did law enforcement arrive?
Yes,
What did you tell law enforcement? What happened that day?
I got hurt.
You got hurt? Who hurt you? Your Honor, I would,
Well, let's try another. What time of day was this? Was it dark out?
I don't know,
Do you know what time you called the police?
like around 9, I believe.
All right, why don't you go from there, Mr. Marvin?
Your Honor, could I guess that one thing I could request is that I examine this witness as like cross, I guess, as a hostile. I could treat her as a hostile witness. I'd ask that. Otherwise,
This is where the courtroom turns tactical. The prosecutor is basically saying, "Judge, she's not cooperating. Let me treat her like the opposing side." In legal terms, that means the prosecutor wants permission to ask leading questions, the kind where you control the narrative. Isn't it true that, instead of open-ended, what happened? Why does this matter? Because a reluctant witness can derail a case with 2 words. I don't remember. And Jesse Pike is already doing it. It's the most common shield in DV cases. Not saying it didn't happen, but saying, I don't know, I can't recall. It's blurry. That way you're not directly accusing anyone, but you're also not giving prosecutors usable testimony. And look at what the prosecutor is warning: reschedule. That's not ideal. Witnesses disappear, fear sets in, stories change. And this is why prosecutors push hard to get a record made while the witness is actually on the stand. This is also where the judge's role becomes critical. A judge has to balance fairness. You can't bully a victim, but the court can't allow a witness to undermine a lawful subpoena either. Audience question: do you think the victim is scared? Or is she intentionally protecting Sean? Or both?
I'm afraid this might be a situation where I have to request other testimony in another way. We might have to reschedule it.
All right, well, Mr. Bush, any response?
My client's. I'm not satisfied with, we've reached a level that she can be treated as a hostile witness, but I would have no objection to a brief recess if Mr. Marvin wants to talk to her.
All right, well, let's see where we go here. Miss Jordan, Miss Peterson, or excuse me, Miss Pike, let me get it right. You got a subpoena to be here yesterday.
I did not get a
Okay, but did you get a subpoena to be here?
inadvertently, they had 11:37 large court.
That's what it
That's
says
fine.
here.
It's 11:35.
All right. Well, you're here now. Did you come with a subpoena?
No, I came because the police tracked me down at my work.
All right,
This was a verbal agreement to come back today
all right.
after yesterday. She cooperated and was
Well,
good
yeah,
about it.
yesterday we got delayed, so we set this for today. Are you uncomfortable being here?
Yes,
And did you talk to Mr. Marvin about this case?
yeah, yes.
And are you reluctant because you don't want Sean to get in more trouble?
No, I don't want him to get in trouble.
He's in trouble. And he's been charged with these criminal offenses. You have a obligation, as you're under oath, to answer the questions truthfully. And so I'm going to allow Mr. Marvin to do this as if he were cross-examining you.
That right there is the judge laying down the law, and it's not optional. The judge is basically saying, this isn't a casual conversation. You're under oath. You don't get to pick and choose which questions you feel like answering. This is important because in popular culture, people think witnesses have the same rights as defendants. They don't. A defendant can remain silent. A witness under subpoena? In most situations, they must answer unless a valid privilege applies, like Fifth Amendment self-incrimination. And the judge explicitly says she doesn't have that privilege here. Also notice, the judge gives the prosecutor permission to cross-examine his own witness. That's a major signal that the court sees the witness as reluctant and evasive. The prosecution is now allowed to push harder and get more direct. But here's the bigger issue. The prosecutor needs specifics. What happened, when, where, how injuries occurred. Without that, proving elements like strangulation, unlawful imprisonment, and aggravated DV becomes difficult. And Jesse's refusal to answer questions like, how did you get the eye injury, is not minor.
As a reluctant witness.
Thank you, Your Honor. Jesse, is it true you contacted law enforcement for help?
Yes,
And when you got there, is it true you had injuries?
to my eye.
All right, so you had an eye injury. How did you receive the eye injury?
All right, just a minute. Can you answer that? How did you receive the eye injury?
The record can't reflect she's shaking her head no, Your Honor.
Are you unwilling to answer the question?
I don't want to answer.
Your Honor, may I ask a series of yes or no?
Let me explore this a little further. I don't want to answer isn't a sufficient answer. People are often here and they have to answer something they don't want to do, but you're here pursuant to a court order and you're under oath in a capital case. So the fact that you don't want to answer the question doesn't mean you don't have to answer it truthfully. So you indicated that you were injured. Can you tell Mr. Marvin how you got the injury?
During the argument, I don't know exactly what happened. I was kind of flailing around. I don't know exactly what happened.
All right, Mr. Marvin, you can ask questions.
Where did that injury happen? Where were you? Oh, so you're in the bedroom. Why were you flailing?
Because of the argument, and I was worried and instantly felt like I wanted to get out of there.
Were you not able to get out of there? Jesse, is it true that you were in the kitchen making toast? You bumped the refrigerator door, hit you. You got mad, or Sean got mad because you're in the way and he hit you. You took your toast and you retreated to the bedroom?
Stop. Is that true?
I don't remember being in the kitchen at all.
All right. Your Honor, I don't know how to move forward. I could move forward and treat this victim as though she died that night, and I am afraid that's what I'm going to have to do.
Well, these are very difficult cases. We had 3 this week where they're alleged to be very serious assaultive injuries inflicted by men on women. In each case, the female, the complaining witness, was reluctant to testify. I had a very bad case yesterday where an animal was killed, and I had another case where a woman was badly beaten about the face. And now we have this case. So in each of those 3 cases, the victim was reluctant to disclose under oath what had happened. If they were dead, they would not be able to disclose under oath what had happened, which makes the witness unavailable and allows for some hearsay. In domestic violence cases, there are specific hearsay exceptions. I don't have the statute right in front of me. Mr. Marvin, do you happen to know the site for that?
I don't know the site for that. And unfortunately, I'm not prepared because the officer who took the statements while he was here yesterday could not come back today.
All right.
I believe it's something 27B, Your Honor, but I don't know the numbers.
It
that lead
is
to it.
769 27B, I think. But it's more expansive than that. 769 27B.
This is the judge stepping into teacher mode, and honestly, it's one of the most legally insightful moments in the transcript. Judge Middleton is explaining what every prosecutor and defense attorney knows. Domestic violence cases often depend on hearsay exceptions because victims frequently become unavailable, emotionally, mentally, or practically. Now, hearsay is typically not allowed because it's an out-of-court statement offered to prove the truth of what it says. Courts don't like it because you can't cross-examine a statement. But in DV cases, lawmakers created exceptions because otherwise abusers could silence victims and automatically win cases. The judge even compares it to if the victim were dead, which sounds harsh. But legally, it's the same concept. If the witness won't or can't testify, the prosecution may still be allowed to use certain statements, like what she said to police shortly after the incident. But here's the problem. The prosecutor isn't prepared with the statute in front of him. That matters. Judges can't just assume a hearsay exception applies. Prosecutors must follow procedure, notice requirements, and evidence rules.
Different. I have it in front of me. Yes, there are exceptions for hearsay.
Seven 68-27.
That's one off.
Yeah, so 768-27B and C.
Does have a notice requirement, but in
Yes.
a preliminary examination, you can't do the 15 days notice. All right. Well, let's try to go as far as we can with this witness.
Okay. Jesse, are you ready?
Throw up.
All right. Did the police come?
Yes.
Did you tell them what happened?
Not exactly. I told them that I had hurt myself doing laundry.
Your Honor,
When they came to the door, that's, you can ask.
All right. I'm gonna continue this matter. You're gonna have to do it as though she weren't here. You're in contempt of court for failing to answer the questions lawfully. And I'm not sure how to deal with that. We'll deal with that in a minute. You have a subpoena. You're here, you're under oath. You don't have a Fifth Amendment privilege not to testify. You can't just not answer the questions. There can be a sanction for that.
This is where it gets real uncomfortable, but also very revealing. The judge has now formally called it contempt of court. Jessie Pike is not just nervous or confused. The judge is saying she is refusing to comply with lawful testimony obligations. And here's what people need to understand. Contempt isn't just a scolding. Contempt can mean penalties. It can mean fines. It can even mean jail time, especially if the court believes the refusal is deliberate and obstructive. But here's the ethical landmine. Jessie is also a potential victim. So the judge is stuck in a terrible position. If he punishes her harshly, it looks like the victim is being punished for being abused. If he does nothing, it sends a message that subpoenas and oaths are optional. And you can literally hear the judge wrestling with it. Meanwhile, the prosecutor is losing time and control. Jessie gives an explanation like, I hurt myself doing laundry. That's not just unhelpful, it directly contradicts the type of injuries being implied. And this is exactly how DV cases die. Not with a bang, but with a witness whispering denial into the record. Audience question, should the court punish a reluctant victim for refusing to testify? Or is that just the system victimizing them twice?
I didn't answer. That's when the door was open.
All right, so let's see where we can go ahead, Mr. Marvin.
Jesse, did you, after an argument in the kitchen, did you go to the bedroom to get away and to de-escalate the situation?
I don't remember being in the kitchen, but I was in the bedroom.
All
I
right.
was laying down.
Okay. How long were you in the bedroom?
— 15 minutes, 20.
All right. And isn't it true that when interviewed, you told law enforcement that when you tried to leave the bedroom, you were pulled back by your hair, and over the course of 30 minutes, you were punched, held down, and strangled.
Okay, this is the prosecution finally putting the case on the table in plain English. Notice the tactic. Instead of asking Jessie what happened, the prosecutor reads out what she allegedly already told law enforcement. That's not random, that's strategic, because when a witness is evasive, you don't let them narrate. You anchor them to a prior statement, and that statement is brutal. Hair pulled, held down, punched, strangled. And the timeline over the course of 30 minutes suggests this wasn't some split-second scuffle. That's prolonged violence, control, dominance, the kind of detail prosecutors need to prove elements like unlawful imprisonment and assault by strangulation. But then Jessie pivots. She says the described event happened in the living room, not the bedroom. And now that might sound like a tiny correction, but legally it matters because inconsistencies become defense ammunition. The defense will later argue, if she can't even locate where it occurred, how can we trust anything? And the judge is watching all of this. In prelim court, the prosecution doesn't need perfection, but it needs enough consistency to show probable cause. This exchange is the heart of the case. Either Jessie confirms the strangulation clearly, or the prosecutor has to rely on hearsay exceptions and officers. Audience question: do you think this is confusion from trauma, or someone rewriting the story to protect the accused?
Like yesterday when I talked about, there was different instances where things are getting mixed up.
All right, so what I just described, did that not happen in the bedroom?
No,
Where did that happen? In the living room? Okay, all right. Jessie, did you at some point try to escape by exiting the house, the door, the front door of the home? Yes or no?
I tried to go out the door. Yeah,
And-
it was locked.
Okay. And were you pulled away from the door and brought back into the house?
Yeah,
Okay. At any point, Jessie, were you choked or
This moment is one of the most emotionally tense parts of the entire transcript, because you can feel the pressure building with every repeated question. The prosecutor asks the most direct, simplest question possible: were you choked or strangled? That's yes/no. It's the kind of question that should take 2 seconds. But Jessie delays, hesitates, doesn't answer. And that silence tells us everything. Because in cases like this, hesitation often means one of 3 things. She's afraid of the consequences at home, she's afraid of the consequences in court, or she's emotionally protecting the relationship, even if it harmed her. And then the prosecutor reframes it in even more clinical legal language. Was your breathing restricted or stopped? That matters because strangulation isn't just hands on neck. It's about obstruction of airflow/blood flow. And strangulation is treated seriously because it can cause brain injury, unconsciousness, even death, sometimes without leaving major external marks. And the prosecutor finally snaps, "I can't continue." That is not dramatic flair. That is the prosecution realizing the witness is actively damaging their case while under oath.
strangled? Jessie, were you choked or strangled?
oh,
Okay. At any point, was your air or your breathing restricted or stopped? Your Honor, I can't continue. It's
Yes. All right.
not accurate, at least with respect to the report and what we talked about yesterday for over an hour.
Yes. Officer Greenhalgh was here, as Mr. Marvin indicated. He had a subpoena for yesterday. Through no fault of Mr. Jordan or Mr. Marvin or Mr. Bush, we weren't able to get to this case.
I do have a suggestion, Your Honor.
Yes.
If we move the case, I believe yesterday you set a prelim 2 weeks from yesterday.
Now, this is a slick defense move, and most viewers might miss it. The defense attorney basically says, "Judge, let's reschedule, and I'll waive the notice requirement so we can move quickly." That sounds cooperative. Almost helpful, right? But here's what's really happening. The defense knows the prosecution is scrambling with hearsay rules, notice requirements, and a shaky witness. A continuance buys time. And time is the defense's best friend when a witness is reluctant. Because what happens in 2 weeks? Witnesses become harder to locate, memories get fuzzier. Victim statements soften, pressure builds outside the courtroom, and the prosecution loses momentum. The defense can pretend it's about scheduling, but it's about strategy. Let the case breathe until it weakens. And the prosecutor? He has no choice but to accept because his key officer isn't available and his statutory notice isn't filed. The judge moves the date, October 10th. So this isn't an emotional victory. It's a legal pivot. This case didn't die today, but it definitely didn't thrive. Audience question. If you were the judge, would you force this case forward today or grant the continuance to do it properly?
I would waive the 14-day notice if Mr. Marvin wants to file the 27B notice and we can proceed 2 weeks from yesterday. Just a thought.
All right. I'm going to continue this matter until Tuesday, October 10th. At 1 o'clock. There's already a bunch of stuff on there, but I'll make a priority for this. Does that work for you, Mr. Marvin?
It does. I appreciate the accommodation, and I will file my notice appropriately and properly under the statute.
Ms. Pike, I know that you're afraid and you're reluctant to be here, and this is a very common and recurring problem.
This is one of those moments where Judge Middleton stops being just a referee and becomes the voice of experience. He flat out says it, "I know you're afraid." And that's huge because judges typically avoid assumptions. But here, he's recognizing the reality of DV cases. Fear isn't an exception, it's the pattern. He even mentions he used to be a prosecutor and has seen this many times. Translation, I know exactly how this goes. Victims often walk into court with the weight of intimidation, guilt, emotional dependence, family pressure, financial survival, and sometimes even threats. But here's the most uncomfortable truth. The judge also warns about perjury, because Jesse's answers are drifting into contradiction territory. The prosecution says her testimony today isn't accurate compared to prior statements. So Jessie is caught between two fires. If she tells the truth and it hurts Sean, she fears what happens outside court. If she denies or lies, she risks legal consequences inside court. This is why the judge asked the haunting question, does the victim get punished twice? And honestly, the system doesn't have a clean answer. This is human tragedy inside legal procedure.
I used to be the prosecutor for a long time before I was judge. And I've seen this problem many times. And even though you're not cooperating with your subpoena,
Forgot a subpoena.
all right, well, you're here, you're under oath, and you're declining to answer the questions. You did answer, I guess, eventually, although Mr. Marvin feels the answer was not truthful, which places you in a position of potentially being charged with perjury. So the question is, what do you do? Assuming that the allegations are correct and you were beaten and choked and strangled and had your eyes swollen shut.
This statement from Judge Middleton is powerful because it's the court acknowledging the likely severity without officially finding facts. He says, assuming the allegations are correct, that's careful judicial language. But then he lists the injuries in a way that makes the courtroom go quiet. Beaten, choked, strangled, eye swollen shut. And notice what he's doing here. He's reframing the issue away from, why won't you talk? And toward, what is justice supposed to look like here? Because punishing a victim for not cooperating might satisfy courtroom authority. But it can also discourage victims from ever calling the police again. If the system teaches victims that reporting abuse equals subpoenas, pressure, contempt, potential perjury threats, then victims stop reporting, and violence gets worse behind closed doors. And that's why this hearing has two stories running side by side. The legal story, evidence, probable cause, statutes, the human story, fear, dependence, survival. This moment is the judge confronting the paradox. The court must enforce law, but also avoid becoming another weapon. Audience question. Do you think courts should treat reluctant DV victims differently than other witnesses? Or should the oath be the oath, no exceptions?
Are you then further punished by the court for failing to cooperate? We've been struggling with that the entire time I've been in the system. So, Mr. Marvin, are you going to give her another subpoena for October 10th?
Yes, I am. I'll give that a shot. We'll continue to work and support her the best we can. We've got Marissa and I met with her. Officer Greenhalgh and I met with her. I understand the situation she's in and we care about her, and we'll try on the 10th.
I have a couple of questions. Are you still at the Millard Court address
Yes.
with Mr. Jordan's father?
This might seem like a small detail, but it's very telling. The judge asks about where Jessie is living, whose house it is, whether Sean's father is there, and whether she might be alone with him. That's not the judge being nosy. That's the judge quietly thinking about witness safety and intimidation risk. Because in DV cases, it's not only the defendant who can influence a witness. It can be family members, friends, even community pressure. The judge is basically doing a wellness check in open court. Jessie says her name is on the lease, meaning she has legal standing as the renter. That reduces the risk of her being trapped in someone else's controlled household. The court doesn't say it out loud, but this matters. And it also shows why Jessie is reluctant. She's still living in an environment connected to the defendant. Even if Sean is in custody, the social pressure remains. This is why prosecutors try to connect victims to advocacy services. Courts can't solve emotional captivity, but they can try to reduce the immediate danger. This moment is the court acknowledging. Testimony is not just words. It can have consequences.
No.
All right, I thought he was
He's in
with,
the nursing.
okay, so he's not there. Whose house is it?
Bart Trammell.
And you're a renter.
Yeah, he just put my name on the lease.
So your name is on the lease.
Yeah.
Very good.
No, please, yeah.
All right. Well, I was just concerned if you were going to be there alone with Mr. Jordan's father.
No.
All right. All right, we will continue this with the availability of Officer Greenhalgh, perhaps body cam videos, photographs, anything else, and try to complete the preliminary examination. Mr. Bush proposed the date. Mr. Jordan is in custody in lieu of a very high bond. he is charged with a 25-year mandatory minimum offense.
All right, here's the courtroom reality check. Sean Jordan is in custody on a very high bond, and the judge reminds everyone why. The charge has a mandatory minimum 25-year sentence attached. In practical terms, that means the court sees this as an extreme risk situation, the kind where release could pose danger to the victim or the community. High bond isn't punishment. At least legally, it's not supposed to be. It's about ensuring the defendant appears in court, public safety, preventing witness tampering. And witness tampering is the elephant in the room here. The judge even states it's apparent the victim witnesses were reluctant. John, that's judicial language for something is influencing this testimony. And that influences everything. Why the prosecutor offered a plea deal, why the prosecutor asked for hostile witness treatment, why the judge keeps warning about obligations under oath, why the case gets continued rather than collapsed. The judge is also signaling we are not letting this slide. October 10th is not a casual reschedule. It's the court preparing to bring in body cam, photos, officer testimony. Basically, everything that doesn't depend on the victim's voice. And when cases reach that point, they become war.
It's apparent that the victim witness is reluctant to testify. So bond will stay where it is, and we're going to try this again on October 10th.
Thank you.
All right, thank you. I'll be in recess.
Thank you, Judge.
Thank you. Miss Pike, you're free to step down. Would you accompany Mr. Marvin out? Sorry about all the waiting around.
Don't think so. Maybe if you could hold on to him for just for a few moments, maybe.
Mr. Jordan, I'll see you next time.
He's talking to her. I'm just going to sit tight.
All right. Well, that is an age-old problem. Does the victim get punished twice? I don't know the answer. I don't know what happened. I wasn't there. The affidavit is quite powerful. All right. Well, that's as much as we can do today. We'll be back again tomorrow with more stuff.
And that right there is the most haunting part of this entire hearing. Judge Middleton openly admits the hardest truth. Does the victim get punished twice? Because in cases like People versus Sean L. Jordan, the legal system is trying to do two jobs at once: protect an alleged victim and enforce the law against an alleged abuser. But when the victim becomes reluctant, fearful, or inconsistent under oath, the courtroom becomes a place where justice and trauma collide. Let's summarize what happened professionally. This was a preliminary examination, meaning the court was determining whether there was probable cause to believe crimes occurred and that Sean Jordan committed them. The defendant faced multiple serious allegations, including unlawful imprisonment and assault by strangulation, and with an added habitual offender enhancement creating a potential mandatory minimum 25-year sentence if convicted. A plea offer was discussed that could have removed the mandatory minimum, but it was refused.